And a 7-judge constitution bench of the Supreme Court has ruled that an MP or MLA cannot claim immunity from prosecution on a charge of bribery in connection with the voter speech in the Parliament or Legislative Assembly. In a unanimous view, the Supreme Court's constitutional bench overruled the 1998 judgment in the P.V. Narasimha Rao case. The court expressed a disagreement with its own judgment in P.V. Narasimha Rao case, which grants immunity to legislator for alleged bribery for making a speech or vote in a particular manner in the House that has wide ramifications. The top court held that corruption and bribery by legislators destroy the functioning of Indian parliamentary democracy. The bench headed by the CJI said that the bribery is not rendered immune, citing Article 105 or 194. The Supreme Court said that the interpretation of P.V. Narasimha Rao judgment is contrary to Articles 105 and 194 of the Constitution. Also, Chief Justice Chandrachud further observed that the offence of bribe is crystallized on the taking of illegal gratification, and it does not depend on whether the voter speech is given later. A bench of 7 judges, headed by the Chief Justice of India in October, reserved order after hearing the submissions. Other judges on the bench are Justices A.S. Bopanna, M.M. Sandresh, P.S. Narasimha, J.B. Pardiwala, Sanjay Kumar, and Manoj Mishra. And for more on this, we have our correspondent Vikas Sarthi joining us. Well, Vikas, a landmark verdict today. Supreme Court said no immunity from prosecution to MPs and MLAs and categorically overruled the 1998 P.V. Narasimha Rao verdict. What were the key observations of the Supreme Court judgment?
Right, Lepakshi. So the Supreme Court was of the view that the 1998 judgment was a flawed judgment. In fact, Supreme Court has said that whatever immunity has been provided to MPs and MLAs are meant for their right to speech in the House, and it is not meant to protect them from acts like accepting bribery or favors from individuals or from other parties. So Supreme Court has made it very clear that this immunity is available only when this immunity is exercised cautiously. Apart from it, court has also held that the interpretation given by the earlier judgment was wrong, and apart from it, court has also held that the same principle, whatever Supreme Court has said today, will be applicable in the Rajya Sabha election as well, and in the elections related to the Vice President and President of India. So in a way, Supreme Court has given a major shift towards how we see the privileges and immunities to the legislators, and court has made it very clear that these immunities are given to raise the issues related to the common man, and it cannot be exercised to gain something, to get undue favors from individuals. Whatever the earlier provision is that if an MP or MLA says anything in the House and votes in a particular way, though the voting was guided by the whip's rule, that whatever chief whip of the party gave the instruction to its MPs and MLAs, they had to follow it. But the statements or the speeches were completely beyond any kind of control, and whatever can be said by the MPs and MLAs, and it will not be, it cannot be a ground of any kind of prosecution. even for accepting bribery or some undue favor for that particular speech. So court has made it very clear that if an MLA or MP receives any kind of bribery and undue favor for any statement, he will also have to face the prosecution under Prevention of Corruption Act. So the kind of immunity which is being exercised by the legislators as of now, it will not be applicable in the future.
All right. Thank you so much, Vikas, for that information. A landmark judgment indeed.